Now, this is an interesting case on a number of levels. The facts are kind of interesting, and I have in the slide here sexting. They really weren't sexting, I suppose. I mean, they were, as the facts illustrate, these are these kids. They're having sort of sleepovers. They're goofing around. They're testing their boundaries. Maybe they're doing some things. Certainly, as a father, I would not be too happy about my kids doing, because they're kinds of activities that I think you can sort of get yourself in trouble with. But there are things kids do. So you can see from the facts what these kids were doing. And the twist here is that these kids are on the school volleyball team. There are another group of kids on the school volleyball team who aren't involved in these activities. And you seem to also have different groups of parents. It seems like there's one group of parents who maybe is a little more tolerant of this kind of conduct. There's another group of parents who is not tolerant at all, apparently, of this kind of conduct. And it's causing these divisions among the kids in the volleyball team. And the school administration decides to get involved. Now, this is not a bullying case, right? But the school administration decides, well, we've got policies about the way our athletes are supposed to represent the school. So this, and the court seems a bit alternatively amused and annoyed that this case becomes literally a federal case. But the district judge decides it and says, well, this activity is happening outside of school. It's some kids at a slumber party. And it can't be said that this activity materially and substantially disrupts the work and discipline of the school. And, as I mentioned before, part of this is playing off that Tinker standard. So, to what extent does the Tinker standard allow a school to regulate the speech of students? And the court, as you see from the opinion, goes through, is this speech? And the court does say, yeah, this is, even though it's kind of dumb and crude and all of that, it's protected speech according to this court. And this court says it's not obscenity, it's not child pornography. I mean, these are, little lollipops and things that are clearly not actual sexual conduct, this court says. So, how far does Tinker extend? Does it allow schools to regulate this kind of conduct? And that kind of question is going to, I think, continue to arise as we have these sort of virtual cyber issues that spill over into the school world. Everything from taking silly pictures at a sleepover party to real sexting issues to real serious bullying and harassment issues of the kind that we saw in the opening video. And the court says, this is at most 15 and 16-year-olds just kind of being 15 and 16-year-olds. And the school policy, and I thought this was a really interesting piece of this case, the school policy talked about whether out-of-school conduct could bring discredit or dishonor upon the student or the school, and that was part of that student-athlete code. And this court says that was overbroad and vague. And at least on this piece, I think I have to agree with this court. If you it's almost an Orwellian kind of speech. If you bring discredit or dishonor on the institution, you may be subject to discipline. On the other hand, query how many schools, public schools as well as private educational institutions, including even our own fine institution, may have codes of conduct that say similar kinds of things that might subject you to some kind of discipline. Now, some of those might be contract-based issues, but some of those overlap with these educational policy issues in a very interesting way. So the next case I asked you to look at was DC versus RR, and this is actually one of the kind of longest running sagas that I'm aware of in this area of what could be called cyberbullying. And we'll go through the opinions in this particular opinion, part of the case that you were assigned to read, and then I'll talk a little bit about other things that have happened in the litigation in this case. So you look at the majority of opinion in the case, and factually, you can read the facts in the case. You see that it's a young man, a high school student, who is involved in the arts, music, film, things like that. He has a MySpace page. Again, this was when MySpace was a place where budding musicians and artists, I think, posted a lot of stuff. But he had social media sites showing off his talents, and he had other students at the school then find this site and post some really vile comments about this student's sexuality, and containing what seemed like explicit threats to do this student harm. And so the context is the student and the student's parents, on behalf of the student, file lawsuits against the school district and against the parents on behalf of the other students who are harassing DC. And then the parents of those other students file an anti-SLAPP lawsuit. And some states, including California, have statutes that allow you to file a claim that a particular lawsuit has been filed for the purpose of cutting off free speech. That it's really not about the merits of the case, but the case was filed really to cut off free speech. And so essentially the procedural posture of the opinion you're reading is under this SLAPP statute saying the plaintiff's case against the individual defendant should be dismissed because it violates this SLAPP statute. It's not really a legitimate speech. It's trying to suit. It's trying to muzzle speech. And the majority opinion of the court says, no, it's not a SLAPP issue. And the question really turns on, were these comments on this kid's social media page, were they protected speech? Were they speech, for example, about someone who's put himself in the public light by putting his acting and singing materials out there so that people could comment on them, even comment harshly and in ugly ways, but still comment? Or were these true threats? And again, if you've covered any of this in constitutional law, you'll recall this. If not, it's relatively straightforward. You have the right to free speech. That right is not absolute. There are certain things, incitement to riots, for example, the government can regulate, and true threats the government can regulate. So the question is this true threats? And one of the interesting legal issues in this particular case is, well, what do we mean by what constitutes a true threat? Is it subjective, meaning that the person giving the speech actually intended a threat? Or is it objective, meaning a reasonable person would have perceived it as a threat, even if the person stating it subjectively may have intended as a joke or a parody or something else? So the majority says, well, I really don't have to decide that, because when I look at it either subjectively, based on the circumstantial evidence of the intent, or objectively based on what a reasonable person would have perceived, that these were real threats, and that the recipient of these could really feel that his life might have been in danger. Further, the court says this is not matters of public concern. You have a lot more leeway in matters of public concern about what you can say or not say. And the court said this wasn't public concern. Just the fact that this kid was interested in an entertainment career and had some things on a website doesn't alone transform it into a matter of public concern. So that's the majority opinion. Now the dissent says, no, wait a minute. Take all these messages and put them in context. And the dissent kind of lays out, as you'll see in the opinion, what each message was and how the messages begin being unpleasant, but not directly threatening physical violence, not directly talking about the kid's sexuality, how they escalate. And the dissent says, if you look at that pattern, it seems obvious that what this was an effort to be funny. That was a very misguided effort to be funny, but nevertheless was not actually an effort to threaten. And the dissent in particular says the subjective standard really has to govern. You have to look at whether the person making the comment actually intended a threat. And here, the factual context, and if you look at some of the language, it's pretty extreme. The kinds of things that the commenters were threatening to do were so extreme that the dissent says they obviously didn't intend to ever carry any of that out. And if you any reasonable person, even under an objective test, reading that whole sequence would see that there's really no actual intent for any kind of threat here. Further, the dissent says this is a matter of public interest under First Amendment law. And the public interest standard, he says, is extremely low, and it can include gossip, and it can include tabloid kind of comments. So if you think about things like threat or things like an intent to cause some kind of emotional harm, think about those tabloid newspapers about celebrities and the things they publish, some of which are just plainly false. John Travolta's baby was abducted by aliens or something like that, right? That's not a threat, but those kinds of things, there's a lot of leeway for tabloids to say. You have other issues about defamation if they cross other lines, right? But you're dealing with a public interest, and the dissent says this is the same kind of thing. This kid was actually, it wasn't just any old website. This kid actually was in a movie. He actually did want to be an entertainer, and so there was some reason to comment on this. Now, I mentioned something about the whole long history of the case, and I want to show you now something from a blog post from a law professor out in California, Eric Goldman, who's one of the kind of top law professors in internet law. And if you're interested in all this stuff, follow Eric's blog. It's really super. But he wrote about some other developments in this case a couple of years ago, and I just want to show you that for a minute. Okay, the last case I asked you to look at was Miller v. Mitchell. This was a celebrated case when it first came out. It was one of the earliest examples of law enforcement getting involved in trying to deal with a high school sexting kind of scandal. And we looked at a couple of those in our previous class, and we had some good discussion about that. So, here's a case where law enforcement tries to get involved and says that, well, if you're sexting, you're a teenager and you're sexting, you've got child pornography. You've got distribution and possession of child pornography. And so to try and break this up, the local prosecutor working with the school district says, well, you need to write a paper explaining why your participation in the sexting activity was wrong. And if you do that, we won't prosecute you. But if you don't do that, we may prosecute you. And the gets up to the Third Circuit, and the Third Circuit ultimately says that would violate the minors' First Amendment rights. To require them to participate in that kind of remediatory activity might cause them to express opinions that they don't actually agree with. They might actually think it wasn't morally wrong or socially wrong. And there were a number of other things. If you read the case, about the program, which included things about gender roles and so on, which I think made it very difficult for the court to swallow. Further, the Third Circuit said the district attorney's motive for bringing this was for threatening to bring prosecution was actually retaliatory for not doing something that would impinge on First Amendment rights. And there's some kind of complicated law about prosecutorial discretion and when a prosecutor can choose to bring or not bring or threaten to bring a case. And so the notion that a prosecutor might threaten to bring a case in order to force someone to speak in a way that they don't want to speak is very difficult here for the Third Circuit to swallow. And further, the Third Circuit said there was no probable cause for the potential child pornography charge, at least on transmission, because the evidence of who transmitted the pictures to whom was kind of lacking. I think that piece of the Third Circuit's opinion is not really that strong, but the other pieces of the opinion, raise all these kind of interesting issues. Now, why do we bring up this kind of child pornography sexting case here in the context of our bullying, threats, stalking, harassment? I wanted to bring it up here because so much of this kind of conduct, certainly not all of it with stalking, but a lot of it with threats and bullying and harassment, occurs with young people and is kind of first discovered in this school context. And the big question I think it raises is, what can law enforcement do about it, if anything? What if the people engaged in the conduct, or at least some of the people engaged in the conduct, think it's actually part of their free speech rights? What if it's even speech that most people would think offensive? But nevertheless, if the First Amendment protects anything, it protects speech that most people probably think is offensive. But at what point does it become something that crosses the line from speech that is, just something that a lot of people will think is offensive to something that's really dangerous and damaging in a way that that the law ought to step in? And so here are the issues that I'd like you to think about as we move toward class next week. So, how do we draw this line between problematic conduct and free speech? How do we draw lines, or should we draw lines, between conduct that involves only adults or conduct that involves only children? Of course, we'll have another set of concerns if it's adults engaging with children. What if it's just children or minors, engaging with just minors as opposed to adults engaging with adults? Do we draw lines? And finally, what kind of remedies are there? If we do see that there are some kind of social problem that should be addressed, how should it be addressed? And in what way, if at all, should the law be a vehicle for trying to address it?